This is Power 102 Digital Friday. On a Friday, the Fathers Association host Hard Talk. Hard Talk starts now. I'm seeing my good brother, Shervon. Shervon, how are you? Good afternoon.
Good afternoon, Mac. How you doing, brother?
I'm cool, as always.
Good afternoon, Trinidad and Tobago. And as always, Mac, much thanks to you and the Power 102 family, Power 102 executive, for creating this space where men can share issues that are pertinent to us in society today. I see Wendell is coming in and out, so I assume he may be getting some connection trouble. I hope that is sorted out soon. But as always, Trinidad and Tobago, it's a pleasure being here with you all. And we have a couple things to discuss today. One being, as the headlines put it out, or as you caption it, Mark, on the Facebook page, Power 102, debunking the myths surrounding shared parenting. And this really stemmed from an article that was published in the Trinidad and Tobago Express earlier this week, where they captured the comments by senior counsel Leslie-Ann Lucky Samaru, who was a part of a panel discussion hosted by the Law Association of Trinidad and Tobago. And the panel was looking at children matters, problem issues with children law. And on the panel, there was also Justice Alison Ramkerry Singh and child and adolescent psychiatrist Dr. Jacqueline Sharp. Wendell, you there? Before I push on any convo, just to give you a chance to say hello.
Good evening, everyone.
Good evening, brother. How you doing?
I'm good, and you?
I'm good. So, Wendell, I was now giving a prelude to what we were going to discuss early today, giving the people insight into what our topic today is based on. And so the first thing of note, well, Wendell, you had a chance to read the article. And before I get into the meat of it, the first thing of note for me, Wendell, is that the article cited that there were 3 people on the panel. And we saw a short video clip, not of what is shared in the article, right?
Yeah.
And however, the reporter goes on, Wendell, to only give the comments of the senior counsel. There's no commentary shared from the honorable judge who was sitting on the panel. The article didn't reference or publish any information shared by the judge, or didn't reference or publish any information shared by the psychiatrist. So one would assume, or one would believe, reading this on the surface, if you didn't get the video clip like we did of other discussions happening in the panel, one could assume, Wendell, that the only thing discussed here was the issue of the senior counsel's disagreement, which I would get into, with the way the court was making orders for shared custody and control. And I have to ask Wendell and Mark, this is, I know you're a media man, but we had to call out the media today. Is this deliberate, Wendell? Is this a deliberate tactic, right, to pollute the views of readers and listeners and people who are going through this issue on this topic? Wendell, there? Unmute your mic, yeah?
Yeah. My point of view on that, I have always been looking at things along the line of an engineered construct, and it was very disappointing to hear someone who is supposed to be a senior counsel, senior member of the law association or the law fraternity of this country, making statements like those. I find those statements to be very counterproductive and destructive. I mean, even I would go as far as to say they're counterproductive and destructive concerning the the rulings of the judiciary and the manner in which the judges and magistrates are doing their job, I find that was actually a slap in the face against magistrates and judges. And I ask myself, where does this individual come off coming across in such a manner concerning how the judges ought to do their jobs? What gives this person the right to take such a liberty to say that? I mean, basically what she is saying is that the judges are not doing their jobs properly. I mean, if we want to break it down, the statements that she would have made is saying that the judges are not doing their jobs properly, and I find that highly unethical. I mean, we know that ethics is something that lawyers has a challenge with, right? We know that. But to come out and openly make a statement that the rulings that the judges are handing down are not good judgments, well then better she run the entire judiciary and she be lawyer, magistrate, judge and everything, right? But to come back to my point, I believe that there is, I'm not a conspiracy theorist, let's get that straight, but the evidence is there to suggest to me that some of these lawyers want to create anarchy in our society so that they could continue to be employed. Because when I heard this individual speak in this manner, she is speaking towards the end that she wants families to be divided. She wants children to not have both father and mother interacting with that child on any sort of equitable level. And the research is there that not suggests but says that children who are beneficiaries of shared parenting do much better than children that are not. I mean, we don't have that research done in Trinidad, but globally the research is there. Is this female counsel not reading? This senior counsel, is she not reading? Is she limited to her opinion concerning what is happening in Trinidad and Tobago? What happened? She's not reading global research reports that says that it is in the best interest of children to have shared parenting in situations where it can be done. So then this is why I have to always conclude that there are certain elements within the various ministries and services that want brokenness in homes, they want dysfunction in homes, they want children to grow up without father figures in their lives so that those children can grow up to contribute to the criminal elements of the society to keep these individuals employed.
That's a very critical point there, Wendell. Very, very critical. Biznat, good afternoon. Thanks for joining us, brother. We see a comment. Folks, Rondell is not 100%. We keep him in prayer for a full recovery. He was trying to be on today, but just so he dropped a comment in the chat, so it doesn't seem like he may or may jump in. But Rondell says in his comment, he said this is frightening that the senior counsel could be or maybe in the next wave of family court judges, meaning to say that given her experience in law and her stature in law, that she could apply to be a judge in the family court. And this is an individual who practices heavily in family law, right? And Rondell is right in that comment. That is frightening. And that is something we definitely have to keep our eyes on.
Shervon?
We need to keep our eyes on that situation. But Rondell ain't even going there yet in terms of possibly in the future becoming a family court judge. Right now, the individual is a family court attorney. They practice heavily in the family court. And so I can only imagine that while we are saying to parents, note this, the Fathers Association has not and never been saying to parents, fathers better and give fathers all the rights and give fathers. No, the message we have been preaching to mothers and fathers is let us work together to parent our children. But here we have an attorney who people are going to for counsel to go to the family court, and their view is no. That is their view. But don't take my word for it. Let me read the article a bit, Wendell, some of the parts of the article. So the listenership, the viewership could hear what was said by senior counsel Lucky Samaru. So she said there has been a move when dealing with custody matters from sole custody care and control to one party to joint custody between both parents. I have found that we have seen the development of what we are going to refer to as shared care and control. And so my interpretation of that statement there, Wendell, the senior counsel is saying that there has been a move and she has found, so I'm assuming she means based on her experience in practicing in the family court, that she is seeing a move by judges, possibly masters and so on, who are progressing the cases to shared what you refer to, shared care and control. And let me say upfront, Fields, I know you're online, Rondell and Wendell, that is what we've been asking for all along. So we are glad to hear that from her experience as an attorney, that she's seeing judges and masters making decisions where they are progressing towards shared parenting. That's number one. She goes on to say that while joint custody refers to both parents having an input in major decisions which will impact the life of the child, the court still has to make an order to determine which parent that child will live with. And that parent will have the responsibility of care and control, which refers to the management of the day-to-day life of the child. She said her position on the issue was a traditional approach, which is one that children have a home. This is her words now in quotations. Children have a home, and they should know where their home is, and therefore shared care and control ought not to be granted except in exceptional circumstances. The bottom line principle is that the court has to put the welfare of the child first. And in my view, this is the senior counsel, in my view, the paramount or first consideration is that the child ought to have a home, a single home. I will pause there for now, Wendell.
So what she is saying, basically what she is saying, that what she is observing is that the court is not putting the best interest of the child first. In other words, that's what she is saying.
Yes.
And that's what I'm saying. She's telling the judiciary, she's telling the magistrates and judges that they are not doing their job properly. I have to ask myself if something is wrong with this individual. How can you come out? And you're practicing. As you said, we can only imagine what she is encouraging her clients to do when they come for her representation before the court, when there are children involved. Can you imagine an individual with such a mindset, what she is encouraging her clients to do? I mean, we are trying to keep children and parents together, not necessarily get them back together as husband and wife, but we are trying to keep children from becoming estranged to their fathers and estranged to their mothers. We are trying to keep children in relationships where they can be parented by both parties, by both mother and father, right? And how could she say that her position is a traditional one? The traditional one is the nuclear family. That's what I know to be traditional, the nuclear family. So what is she talking about? Her approach is her position is a traditional one. Traditional one from where? From the default position that the court had been practicing of giving her father every other weekend, and the child lives with the mother. We are living in changing times. We are living in changing times. At the end of the day, our society today is not what it used to be 20 years ago, 30 years ago, and we know that we are operating under some laws that were created back then that is not working well for today's society, right? And we have been lobbying to have some of these things changed. So for this person to come out and make statements like these, I think it's very disappointing, one, and it's very destructive. It is very destructive to any society that wants to move forward.
Yeah, because this is a senior counsel, Wendell. This is not no junior lawyer coming out of school talking here. You're right. This is a senior counsel whose words carry weight. This is a senior counsel who, I assume, when the government, the state wants to review legislation pertaining to family law, when the state wants to have discussions around policies relating to family law, this is who they will call to the table. This is who they would ask for advice. Right? And this and she's saying that the paramount of first consideration is the child ought to have a single home. And I ask myself, let me read the next paragraph before I say this. Oh, Rondell says here, it serves their financial benefits to keep parents in adversarial. Attorneys he's referring to. And that is true. That is true. You were just saying it when that there are people who benefit from the system.
Correct.
There are people who benefit from the chaos. There are people who benefit from families in separation and in conflict. Because the longer the court case drags out, the more money people get. Let me be frank about it. And Rondell, probably we need to do a study right here in Trinidad and Tobago about lawyers' fees. Right? We need to get people who are in court and who have attorneys to send us some bills so we could talk about lawyers' fees. And we're not attacking lawyers here, you know, all in all. Because we know we have Amelia Mohammed, who is a diligent, young, and ethical professional lawyer, right? We have Kirby Joseph, we have Kerry and Oliver, we have people who we know who they're not part of the association, but they've represented men who've come through us, they've represented men who engage with us. And when we engage with them and we hear their view on families, it aligns with our view, not a man-centric view, a male-centric view, but a family-centric view. And that is the care, that is what the care and well-being of a child means. The care and well-being of a child don't mean the child have a single home. Wendell, let me read the next paragraph because we ain't going to get through this article today. Tied to what she was saying that the child ought to have a single home, she says care and control should be awarded to one party so that a child of 5 who is in school to learn, who is told in school to learn to write the address, let me read that over. Care and control should be awarded to one party so that a child of 5 who is told in school to learn to write the address doesn't suffer from anxiety because they don't know what address to learn to write. They don't know what they need to do. They need to know that they have a home and they get to see the other parent. What garbage, rubbish, and nonsense is that?
So in other words, she is saying that the parents of these children are dumb. The parents will not teach the child or the children what is the reality and what to write, what to say. So not only is she attacking the manner in which the judiciary, the judges are doing their job, she attacking the manner in which the parents are doing their job as well. Because if you are saying that the child is going to be confused, the responsibility or the job of a parent is to teach the child who they are, where they live, what is their situation. I mean, I have 4 children and I've been a single father, and I have one child. I've had custody of the first 3, and the last child, the mother had custody and control of him, and none of my children were ever confused about who they were or where they lived. And
the hypocrisy of this world,
that
right?
is madness.
We have people around the world now telling children there could be boy, girl, animal, place, thing, TV show, all at one time. Right? The same people who telling children there could be a boy today and a girl tomorrow. And now we have people telling them that is not confusing enough. What confusion is that they had 2 addresses. That is confusing. I cannot understand. Put
Yeah.
yourself in the shoes, Madam Senior Counsel. Put yourself in the shoes of a child who is in a separated home. Let me use that same 5-year-old child example you just give, Senior Counsel, and ask yourself, in the top 5 things or the top 10 things that is bothering that child at this point in the life of their parents separating, if to writing down in school, if I have to address, is the thing that causing me anxiety. Ask yourself, learn it, Senior Counsel, that the thing that is really causing anxiety is the fact that I had to write down to address, or the fact that I used to be home and I used to be playing with my daddy in the yard, and I used to be with my mommy in the kitchen, and I used to be doing my maths homework with daddy, and I'm doing my English homework with mommy, and I play watching TV with both of them, and then all of a sudden, it don't exist anymore. I don't know what's going on. I have no access to daddy, or I have no access to mommy, right? And I only seen them ever so often, and they're quarreling, and 2 of them tearing apart, and I caught in the middle because I don't want nobody feel bad. Which one, Wendell? Which one is really causing our child anxiety at this time?
But you see, Senior Counsel is not concerned about that. Senior Counsel is concerned about her paycheck. You see, if she's concerned about the best interest of the child, her paycheck will be compromised.
I tell you, Wendell, you know, when I read this morning, I get upset. And I see the program is quite Friday. I'll have time to calm down. And when I read it this morning, in preparation for this evening, I get upset all over again. I say, Shervon, this evening he'll calm down again. And it really gets into me. You know why? I grew up without my father. Right? It wasn't what we say. My mother didn't alienate him. He made a choice, right? And I know every day, Wendell, when I was a child growing up without my father, it never occurred to me that about to address is a problem. Good evening, Krista. Thank you for joining us. It never occurred to me, Wendell. That was never an issue. You know what was an issue for me, Wendell? You see, when I was playing football or cricket for school, and I looking on the sidelines, my mother was always there. And I thank God for that. But when I see other children there on the team with me and their fathers, they're cheering them on too, that is what bothered me. Right? When I was going through different milestone events in my life, and I didn't have my father there, that is what bothered me. I could have cared less. I didn't give a damn about if it had 2 address and 3 address. I didn't care. All I wanted was for my father growing up to be a parent in my life. That's all I long for. So this, and again, this is not coming, Wendell, from some crazy advocate on the side of the road, right? The government, the state, whichever government it was, I don't know when she became a senior counsel, but whichever of the parties looked upon this individual and their body of work and decided that they would bestow upon this person the title of senior counsel. Remember, that is how you become a senior counsel, right? And so this is someone of repute. This is someone of notoriety. This is someone who practices family law and advises, probably, as I said, on policy. And this is the kind of asinine commentary flowing out of this person. And I frighten now, Wendell. I am grateful that the family court has made progress from what she is saying. And we call upon the judiciary to reject the nonsense that was spewed from the senior counsel's mouth, to outrightly and openly reject it. Let me read on, Wendell. She said, I'm not suggesting that fathers in this day and age should be limited to 2 weekends a month. Thank God. That's not what this is about, because I think without having shared care and control, you can have liberal access. Wendell, I must stop right there on that point. How much people we just have to deal with this liberal access order and the problems that this create?
Actually, I have been for a very long time through this association encouraging people not to fall into the trap of liberal access, because liberal access is a very dangerous trap, because liberal access is dependent on the person who has custody, care, and control, making the child or the children available to the person who has access. And we know that the mothers who have custody, care, and control engages the children in all sorts of activities to use that to prevent the father from getting access when there's a liberal access order. So structured access is the best type of access. So again, it's another, she is trying to entrap fathers by encouraging them into having liberal access orders, and we all know that liberal access orders do not work.
Well, let me go back to Phil's comment, Wendell, about financial benefit. Because when liberal access fails, what has to happen, Wendell?
You gotta go back to the lawyer. You gotta go back to the attorney. Senior counsel paycheck fat again.
So, in case we have listeners who do not know what liberal access means, liberal access means that you and the parent will work out among yourselves how the access is with the child is the flow, right? So I call you and I tell you, hey, come and pick up the child today, and you say, okay, cool, no problem. Tell you I'm taking him this weekend, carrying him to Tobago, right? There's no strict rules as to make sure and give them the child from Friday 6 o'clock to Sunday 9 o'clock, etc., etc. Right? Liberal meaning we have a flexible arrangement, and we would like all parents to get to the place where that is the level of maturity and communication that exists in the raising of their children. Afternoon, Kaede. Thanks for joining us. We would like that to be the place that persons get to. But by our experience, it don't start there most of the time, because most of the time there's conflict. People are reeling from the hurt of their separation and the causes of their separation. And because of that trauma and hurt of that separation, they are taking it out on each other by trying to use the child as a pawn. And so many times, as Wendell was just giving the example, over the years, we encounter mostly fathers where the mother has custody, the father has liberal access, and the father is saying, I'm not getting to see my child. Good day, Keisha. Thanks for joining us. Most of the time, that's what you see happening. And so what does the father have to do? Go back to court and apply now for a structured access order. So yes, we would like liberal access, people to get to the level of maturity where the liberal access is working out, but that can't be the starting point. It doesn't work like that. Rondell Fields is on. Rondell, I know you was listening avidly, so I'll give you a chance to catch up with some contribution. You couldn't take it.
Yeah, boy, bro, boy. I couldn't take it, boy, because it's so hypocritical. Why seen as a condemnation of shared parenting, which we would imagine will be stipulated in a structured pattern. Let's say 1 week by mommy, 1 week by daddy, so that it's balanced time and it still has a level of structure. But then the supposed to be learned senior counsel is suggesting liberal access, which is more chaotic because there is no real structure. That is the most structureless, if that is a description, because it means that anybody have time anytime and make a request and both could facilitate, it is facilitated. So it means in the middle of the week, it means tomorrow, it means next 2 weeks, there's no structure whatsoever when it comes to that. So the child has no idea beforehand where they're going to be, what they're going to do, have an idea which location they're going to be at, because it is liberal access. So it shows to me a high level of hypocrisy. But even the learned senior counsel understands the exact issue you were just relaying. She knows that with liberal access, the custodial parent will then be able to say, or be able to always not allow access to the child. But with a structured access like shared parenting, they will be called to have to oblige. So what she is saying is actually more dangerous. What she is suggesting is actually more chaotic structurally for the child, because there is no clear pattern. It come like a timetable: day 1, day 2, day 3, day 4, day 5. So the child knows, this week I am by mommy. When I get by mommy on this day, I know I primarily stay in my bedroom here. Granny does help me do this, XYZ, XYZ. The child also understands that the week thereafter, if he is by daddy, if there's a different function, he already knows, or she already knows, what the function is going to be, because it is structured and the child understands that is what the protocol is going to be. So it is highly hypocritical, and also just plays to show that the lawyer is just anti-parental shared parenting. That's all she is, and does not care what is in the best interest of the child, because liberal access is more complicated when it comes to sharing access than having a structured shared parental access to the child. So for sure, that is an issue. And I love the point you raised, Shervon, because that in itself was the point I was going to raise myself. Anxiety over address. That child now has to understand that mommy and daddy no longer cohabits. Mommy and daddy no longer goes on romantic dates with them. Mommy and daddy and children no longer in the same space. And that child is made to navigate that. And your concern is that a child, or your belief rather, is that the child is going to be anxious over the writing or stating of an address. What should be the idea in the mind of the learned senior counsel is that if we have reasonable, if we have structured, if we have definite access to both parties, then the anxiety of the child will be at a lower level, so much that the child understands that in this new relationship, co-parenting relationship that exists between he or his or her parents, they now cohabit at 2 locations, and whichever one they are free to use with no foul, with no issue, with no problem. They are free and open to utilize any one of them because they live at both places. Madam, you did a failed and horrid job at even trying to make a point. And when we respond in the media, we will tear you to pieces. I promise you that.
Rondell, and what you're saying there, right? It's in reverse. On the flip side, liberal access, Wendell, that is what should be an exception to the norm. Because we know that there are few cases, very few in our many years of experience doing this, where you have people who split is amicable and mature enough to address the issues that they are facing, and they could treat with it, right? So that is what should be exception, not what she is saying is the exception. She is saying shared parenting the exception. No, shared parenting should be the norm. And Pinky, good afternoon. Thanks for joining us. And Marlon, thanks for joining us. Those are the things. let me read on though. She says, according to Lucky Samaru, there have been judgments from the family court in Port of Spain that allow both parties to feel that they are equally involved in the life of the child when there is shared care and control order. What that does is it puts the interests of the parents before the interests of the child. Because in a court trying to satisfy the parents that they are each equal and entitled to take care of their child and have an input in their development, it does not pay sufficient attention to what is in the interest of the child. Rondell, I see your face looking like you're upset.
But I am more confused and upset because firstly, I am confused that that person will be selected to be put on a panel to represent attorneys if she was selected to, because her experience is grossly limited. We have shown the disadvantages of both parents not being granted satisfactory time with their children. One particularly being the ability to protect that child. We've had the father of Amara here talk about his inability to be able to have meaningful access that caused his child to lose her head. We've had Shervon Reyes himself as well. The inability to have proper access to their children did not give their children windows of escape. Because if the norm was that child knew that the week after they were going to be in another space that they would have considered to be safe to disclose, safe to report, safe to complain to the other parent. We have to understand that other parent's involvement is critical, not only as she makes it sound for the parent to feel as if they can parent. That level of access to the other parent gives the child that extra padded form of protection to be able to tell the paternal father, the paternal grandmother, grandfather, the paternal parent on the next side. If you examine most times, whether it happens with mother or father or some sexual abuse takes place to a child, whether it takes place in the mother's house or the father's house, the persons most time that report this comes from the other party's home. The other parent, sometimes it's not even the direct parent, the father. Sometimes it's the grandmother, the girl tell. We have situations like that. The children hardly ever tell the parent they live with. Look at the young girl we dealt with, Shervon, last year, who was being buggered by the stepfather. She had no contact to her father, who they eventually placed her to live with. You know who she had to tell? She had to report it in school. So you must give them that added opportunity to be able to access protection. So you could never tell me that protection, or at least even the feeling of protection, is not important or beneficial to our child. Just based on what I have heard this senior counsel say, I believe strongly the family court needs to put out some type of procedures for lawyers now. If you want to appear as a lawyer in the family realm, because we understand it is so sensitive and because you're not coming to court to prove guilt or innocence or to defend, you don't have to come in there like a defender and you know a man is a criminal and you're coming to fight a case for him to lie. This is concerning the benefit of the child. I believe it is enough grounds for the family court to have some procedures for attorneys as well, where their interests must lie. And if your interest is an interest that says that you believe in sole parenting and you have no good point or grounds to stand on as the poor, I don't know how bad for advertisement she didn't realize that. Any person who is looking for a lawyer She don't realize that's bad for her business, the statements and pronouncements that she's saying, because it is nonsensical. And any good sitting family court judge should not agree with it. And not to ramp on again, but let me tell you why I believe that statement was said as well. Because Judge Ram Kerry Singh was a part of that panel. And in our study in 2018, she was the sole person who made a shared parenting order. So the findings from that study we did, 66% of the times, the mother based only because of her gender. In cases where the child was in no danger, mother and father had the same capability. 66% of the time, it went to the mother just because she was a mother. 32% of the times, custody and control was given to the father. And 2% went to mother and father in a shared parental rule. Justice Ram Kerry Singh was the only person who did that. And I believe that message and that statement was an attack against what she did.
And this is why we said earlier, Rondell, the judiciary needs to denounce those foolish statements published in that article on Monday. They need to denounce those statements made by that senior counsel, because as Wendell pointed out earlier, I view it, and I agree with Wendell, as an attack on the judiciary and as an attack, as you said, on the judge.
Correct.
Right? On the, as we like to say, the independence and autonomy of the judge.
Correct. That can be by chance. That cannot be by chance, Shervon and Wendell. That particular judge on the panel with you, and you decide to make a comment on that in a nature like that, We should go to the case to see if she was the lawyer, and we have the case. We should go to see if she was the lawyer in that case as well.
And the thing is, she's talking here about putting the interest of the parent in front of the interest of the child. Where's the difference in this situation? Where's the difference? Is a child going to parent themselves? The rights of the parent and the rights of the child are intertwined.
Correct.
In many regards.
That is really
what foolishness is that? But putting the right of the parent in front of the right of the parent to be able to parent and raise their child.
That's
correct. Right of the child to grow up in an environment where they have access to their children, where they have access to their parents, and they can grow up in a productive environment. If we go back to the United Nations Convention, and we do agree with the UN oftentimes, right? But if you go to the UN Convention on the Rights of the Child, right? Especially the child-friendly version, because they have a version they do for children that they share with children. Point 9 says, children should not be separated from their parents unless they are not being properly looked after. Right? Children should not be separated from their parents. Number 10 says, a child should have contact with their parents across countries. If a child is living in a different country from their parents, the government must let the child and the parent travel so that they can stay in contact with each other. That is the right of the child. The right of the parent is to be a parent, and the right of the child is to have parents.
Correct. So I am confused, like you guys are. If the parent is at the court accepting their parental rights, it is, as you guys are suggesting, to be able to parent and to also socially satisfy a request that has been demanded of them to play their parental role in the life of their child. They are actually coming to a court to say, give it to me. But you realize she has already in her statement chosen or understands who she sees always as a non-custodial parent. That is why she says boldly, I am not saying I don't want fathers involved. So she mentions fathers. When you're dealing with, as a learned senior counsel, your language alone should be custodial and non-custodial, because it should be for your better understanding. You should have the better understanding that it could go either way. Or if you believe that there's really impartiality at the courts, You would speak in a manner like that because you would not see custody automatically have an agenda.
Yeah.
But for her to say that non-custody has agenda by saying, I am not saying that fathers shouldn't be in their children's life, it shows that she is already partial. And it shows that at any point she requests to be a family court judge, she should be shut down. And I am telling you from now, my dear lady, anytime you put out your thoughts to ask of that, we will go to every level to stop it. And that is our right as advocates. That is how we protect the society. If we see people make statements that are so partial and are so separative, we as advocates for family life and family unison and co-parenting and shared parenting have a mandate to ensure that persons like that do not end up in positions to make vital ends come to our society.
But I go back to the point you made earlier. The Family and Children Division Act, this is legislation, right? It speaks to judges and masters having the being of a right fit, which is to say, you can't take any judge or master and drop them in the family court, right? They must have a particular department, right fit. And I agree with you 100% on that. That law should be amended to include attorneys as well.
Correct.
If you are not of the right fit,
don't come here.
Don't come here. You don't belong
here. Go in the criminal court.
Yeah, if you are not of the right fit, you cannot practice here. If your goal here is divisiveness, if your goal here is to pour gas on conflict, adversarial here is not the place for you.
Correct.
And that should be written in stone.
Correct. I second that, third that, and fourth that.
We will have to add some psychologists to that list as well.
Yes, correct. No, correct. Every practitioner.
Because I have heard some psychologists that are closely attached to the family court spewing out hate against men.
Agreed.
Right? So when you have people with a mindset like that coming to work in a family court environment, what are they bringing in?
Yes.
They're bringing in division, divisiveness.
Yeah.
Because that statement that the senior counsel is a very divisive statement.
Correct.
And you know something that we haven't touched on yet. Why is it that the news media that carried that particular report separated everything else, separated that from everything else, left out all the other contributions that would have been made at that on that occasion, and only choose to print this one? Why? Is it that just the journalists and the senior counsel in cahoots to get this information out here to corrupt the process?
But I am glad they didn't know, Wendell. Whether if it was by fumble or bad intent or just God job or just God working, I am glad they did. Because if they didn't put it, we would have never seen it. We would have never been able to condemn it.
Yeah.
So what they possibly thought they were doing for their own good will work for evil against them.
Yes.
Because now we are now able to highlight the mind of a senior counsel. Not no common.
In the family court.
In the family court.
And keep our eyes on her.
Partiality.
And keep our eyes on her.
Correct. She can move. She cannot move. You understand?
And what I said when Rondell earlier, not even just move in terms of judiciary. I am saying that I am certain by her stature position that when the government is having discussion about revising family laws, when they're revising family policies, family court policies, and all of these things, that she is invited. I am certain.
You see?
And she will be invited by her stature. She's a senior counsel and experienced practitioner in family court. So it is known that she will be invited to those tables to have those conversations.
And that is why, gentlemen, as we have all put in our 2 cents here, it is important for us to have the family court for us to write to the Chief Justice that there be procedures, as you pinpointed just now, Shervon as well. If magistrates must abide by it and must understand the epicenter is the family, the lawyers must abide by it for them to come and try in this court, and the psychologist also, or any member, any service provided by the court, social worker, everybody, your modus operandi must be family. And family is not one. Family is collaborative. The word family is everybody being involved, nobody being left out. We bringing people together. We're not separating them. That is why you called it a family court, I believe.
Yep.
Because it was meant to be collaborative, corroborative, and working together in nucleus. And if there are procedural guidelines for magistrates to think along that lines, it makes no sense the magistrate thinking like that, and the lawyer who come in to petition them in a whole different direction.
Because they guiding the clients.
Correct.
And they will be leading them astray.
You are encouraging the client of the claims that they should bring, the type of matters they bring before the affidavits to swear and all these kind of things.
Yeah.
The affidavits are applied for. You understand? So instead of working together for the benefit of the family, you would be in the ear of that client, encouraging them to go in a divisive kind of direction, which is counterproductive to the benefit of the child.
Correct.
The child parents are already separated. They don't need them further separated. They need them to come together.
Yeah. Marlon says, do they really care about fathers? I'm beginning to believe that there's an attack on all fathers who in the court for whatever reason concerning their kids. Marlon, the question is, do they even care about children?
That is what I was thinking.
I don't even think they care about children.
We know they don't care about fathers.
Right? We know they don't care about fathers. But do they even care about children? Because if they did, this is not the kind of things that would be said. Let me read on, gentlemen. Let me wrap this article up.
Let me just put in something. I think that there are members of the judiciary that do care about children, that do care about fathers, that do care about family.
Wait, remember, Wendell, this is not a member of the judiciary.
Yeah. But let me finish. But I think that there are certain elements that are trying to poison the minds of the people by these kinds of surreptitious statements that they are making. Right? I just want to put that out there because at the end of the day, we see that there are judges and masters who make judgments that are in and orders that are in the best interest of the children. But when individuals with these kinds of divisive thinking and divisive statement comes in, these elements are trying to corrupt that process. That is working, right? They're trying to actually corrupt what is working.
Correct. And before we move on, Shervon, I want to jump on what Wendell says there, because it as we talking about it now, it's all making more perfect sense to me. Because imagine you are an attorney and you promise your client, I will get this for you, I will get that for you, I will get this for you. And then you go in a court and a judge, or you're seeing a pattern, as she seemed to mention, if I heard you read correctly, of judges starting to move towards sharing parenting. It now takes away from you, from your so-called granddad, to be able to give one party everything. So in an attempt to deter the judges, because she sat on a panel with a judge there, and a judge who is known for possibly doing the first or making the first official order that was shared parenting, she decides to say it, to see if she could do exactly what Wendell suggested there. To reverse the trend that is now working towards having mothers and fathers, co-parents, having children have access to their both sides of family, both the paternal and the maternal sides of the family. And to me, that is dangerous, devilish, and selfish for an individual to do.
But what they should do? You know, politicians have to declare, right? They should declare how much money they make in these family matters when they drag out like that. No, because
Maybe
there's a
it's time
conflict
for
right
that.
there. There's a conflict right there. The longer the matters drag out, is the more money attorneys make.
Correct.
Right? So the fact that you will pick a divisive
Correct. Approach. Opposed to wrapping it up quickly.
You all hear me, gentlemen? I think I got cut
Yeah,
off there.
you know.
Right. The fact that you would pick a divisive side as opposed to picking the line or the road that will bring families together and have less conflict. And so if there's less conflict, there's less repetition in the court. Right? Which means it has less to make. Because we know Wendell and we know Rondell, every time there's conflict, you're back in the court, and you're back in the court, and you're back in the court.
Correct.
Right?
Correct. Conflict with that court.
This is it. Shared care control. Shared care and control. Folks, sorry, my bad. I saw a commenter there asking if they could call in anytime, folks. I'm going to just call out the number for you there. My apologies. You can call in anytime. 222-8255. 222-8255. Right? If you're calling from the US or Canada, it's toll free. You can call on 866-525-1099. And if you want to message us on WhatsApp, it's 868-318-1021, or you can message us on the social media platform here. She opines, shared care and control should only be limited to cases where it is by consent. Because the difficulty I have is that where there is a lot of animosity between parents, the imposition, so the court imposing herself, this is what she's saying, imposition by the court of an order for shared care and control does not, in fact, dial down that animosity. It exacerbates it because there's a lot of pulling and tugging of the child between parties.
Boy,
Do they do psychological evaluation for these individuals? Because to me, it sounded like this individual needs a psychological evaluation.
Yeah. I'm sure she realized what she said.
I don't know. 1 minute
That
after
is so contradictory.
all I could do is laugh.
It is so contradictory what she's saying. Where in your life you hear people sharing, it actually make it. I don't understand.
So hear this, right? Let's not hear this, right? So what she's saying. She's saying give them liberal access, right?
Right.
Liberal access will be less contentious. I gave you all the explanation of what liberal access means. There's no consequence, no structure, no anything, right? And she's saying where the court mandates or imposes, to use her words, imposes an order of shared parenting so that we know we have rules to abide by, there's more conflict.
That's the same thing we saying, Shervon. That's the same point we're making with liberal access. That from the time we heard she suggests liberal access, we understood she's talking foolishness. We understood that she just came to speak on an agenda, and we understood also that she understands when you give liberal access, the custodial parent could still never give you the child. She understands the shortfall of liberal access. It means that she knows that liberal access is not carrying out the duty the court hoped it would have. It means she's aware of that. That's all. Because if you are saying that liberal access is fine, right? If you are saying that liberal access is fine to give, which happens haphazardly, which is supposed to happen, if the father say, call here every single day next week and he want the child and he could get the child, you're supposed to give him it. Because once he could facilitate the child. And then the week after, if he can't do it, he can't do it. So how could a structureless form of access make more sense or be less contentious than one that is structured? Because just reasonably thinking, fellas, a man might want access on a day, really and truly, that the mother cannot give him. But then he could then tell himself maybe she's being spiteful. At a time, she may not really be trying to be spiteful. And that will cause contention, not so? So that is exactly what we are saying. That is exactly why you rightfully said, and Wendell, you all were saying, that when people call us who have challenges with liberal access, we often advise them to go back and try to get structured access. That way we know that persons have guidelines to follow and that they don't end up in any type of contention because my times don't work at the same time with your time. I confuse.
So let me tell you, let me give the learned senior counsel something. Because Wendell asked earlier, Wendell said earlier, as a senior counsel, the expectation. Law is a lot of reading. When Rondell, you know that you studied law. Law is a lot of reading, right? There's a recent study in Spain, 2020, which we spoke about at length in previous programs. And Spain took the decision to pass shared parenting laws, joint custody laws, as they call it, right? Giving more equal parenting time. And this published study indicates that in just 5 years after that law had been passed, prior to the law being passed, the number of joint custody given was around 11%. And after the law was passed, in just 5 years, the rate went up to 40% of cases. The court was awarding joint custody. And what the researchers found is that domestic violence, which is born out of conflict, intimate partner violence, started decreasing rapidly to the point that in comparing the same time that joint custody was awarded and comparing the same period of intimate partner violence, they found that intimate partner violence decreased by 50%. So the point that the learned senior counsel is making, that given shared custody and control actually increases conflict, is not found in this research.
At all.
Right?
And it makes sense.
Correct.
Go ahead, Wendell.
No, I'm saying, and that's what I was saying earlier. The research is out there, right? Where in practice it has shown the benefit towards children and shown that it serves to bring, to create a better society, to create more amicable situations. Right, and that's what Shervon is saying there is just one aspect of it, because that would also speak to a reduction of crime, because you're producing less criminals because children have guidance, less teenage pregnancy, less drug abuse, and all of those things. The research is out there, right?
Correct.
So this is why it blows me away to see and to hear a senior counsel. So what is this individual is not reading then? She just grabbing things out of her hat and speaking.
Fellas, let me not even go to the research part of it. Let me just use common sense based on our experience and based on experience that everybody will have experiences. Why did they come to the court in the first place? Didn't they not come to the court because they could not make an agreement on their own? Is there a law that says that mothers and fathers, if they want to share parenting or want to share access of their child, they need to come to court to make it? No. There's no law that says so. So the main fact that they have come means that they are in a position where on their own they cannot make reasonable and impartial decisions.
That's right.
So they have accessed the court for a mediator, the court, to do so on their behalf so that they don't have contention between them. So it is ludicrous that you would be so irresponsible as a court to know that the reason two persons are coming to you are for you to assist them because they could not do it on their own, and then prioritize liberal access, which requires persons to have a level of intelligence, emotional intelligence, and a level of capability to co-parent to perform well. So the beginning and starting point must be for the court to do what the people came there to do what they could not do on their own. Intervene, put some type of structured access that they both can abide by, and then later on, if things get better, it could go to liberal access. But you can never start at liberal access, because then why they come to the court in the first place? If they could have just, all you tell them is liberal access, and you still leave the decision making up to them, right? Why they come to court in the first place? They came to court because they could not do it on their own. And they came for a mediator that has the legal ambit to do it for them, at least at this stage in their co-parenting relationship. So even if we just use common sense, huh?
So in a nutshell, what the senior counsel is suggesting is that the judges exacerbate the situation.
Correct. She's telling the court not to do anything, and that is the smarter thing to do. They came in one position, give them an order to go back home in the same way. That is what she's saying that they should do. So just from a commonsensical standpoint, they came for a purpose. And if the court is moving in a direction of a purpose to get them to work together, not just for their benefit, but for the benefit of the child, and so the child could experience both the best out of the worst. Then they're already dealing with a separation, but they want to be in granny life on both sides. They want to be in grandpa life on both sides. They need somebody to protect that interest for them and give them that opportunity too. And that's why you came to the court. So just off of that merit of common sense, you could never prioritize liberal access, which is, as we've been saying, the one that could actually lead to acrimony over structured access. And that is why it makes sense what you're saying, Shervon, as well. Because now you've given them nothing to quarrel and fight over. The court has made this order, the man didn't make it, the woman didn't make it, and they must now abide by it and follow the court's order. So what are we going to quarrel for? The only thing that could cause acrimony there is somebody deciding to breach the order.
And in doing so, you give the court the authority
to
take action against you. So it's not making sense. So I could understand the statistic cause saying it to go down, saying that it goes down.
Yeah. She goes on to say, shared care and control cannot work in cases where the parents live far distance away from each other. They may be living with the father, which is 2 minutes from the school, and then have to go to the mother, who lives an hour and a half from the school. And so there is going to be a difference as the life of the child will change. But the life of the child has already changed.
That's right.
I made that point earlier.
That's right.
The 5-year-old child example that she used, who was coming home and accustomed wrestling with daddy and playing with mommy and cooking with daddy and out with mommy and doing all these different things, going movies together, as you say, Rondell, going out together as a family. That is no more. The life of the child has changed.
Correct. And I mean, this is why the orders need to reflect in a particular way. If daddy live in Grandy and mommy live in Trin-City, put the child in a school in Arima. Simple as that. That's where it is. That's part of where it is. Simple as that. There are adjustments that can be made. And then persons will take into account, if daddy leaves and he knows the child going there and he knows that he's going to get, it is expectant or the norm for him to still play a pivotal role. He's not going to rent in Kunupia if they're from Grandy originally. He finding somewhere right in Grandy. But it is because we've created a culture of one parent being the prioritized parent. The other parent know they could go mad.
No, but it's not the other parent could go in, because what you see happening is the custodial parent is the one who just pick up the child and
And you
go.
sometimes too.
And go. Because they're telling themselves is you to catch. You have to come and see the child.
Just fight for that.
So both are we living in a room all the time, and now I go on 5 is bad to live. I go on 0.14. And a
Correct.
0.14, and it's you to catch.
Correct.
You come coming and see the child. Right?
Correct.
You to catch.
Correct. So actually what she is suggesting is encouraging people to abuse that custodial right they have and to distance themselves by location or geographically to the disadvantage of the other parent. To then frustrate the parent that is left behind, to now cause acrimony between them, and acrimony that can lead to anger, that can move to violence, that can end in death. We don't talk about this part, but that is the truth of it.
And that translates into one thing. You know that at the end of the day, all of what you just mentioned there translates into one thing: money.
But I say, we say to women all the time, and I'm not talking about the senior council here specifically, I'm talking about the conversation in general now. The people who many a times on the platform speaking about domestic violence, I honestly believe they don't care about you.
Yeah, could never care.
Oftentimes the things that they are suggesting increases conflict. And they are unwilling to have conversation about the things that decrease conflict. They're unwilling to listen to it. And as Wendell said, there is research. This is not Rondell, Shervon, and Wendell who given their opinion alone.
Correct.
Scientific research to back up the things that we are saying. And if there is science, during COVID, what is one thing they tell us all the time? Trust the what? Trust the science. Trust the science. Trust the science. But when it comes to family matters and conflict and the things impacting children, there's science out there. How we in here and all the people saying trust the science? There's scientific research out there. So I lost. Let me read the last paragraph, and that I could never see this article again. Please. So unless parties live close to each other, right? We said that already. Well, we talk about her opinion on living arrangements. No court, this is her last statement, no court ought to make an order for shared care and control unless there has been at least a 6-month trial period to see what impact it has on the child. And again, the senior council has everything in reverse. To me, no court is to make an order for liberal access until you see that both parents have the level of maturity and have processed the pain of separation and could go ahead and have discussions and decisions on their own.
Correct.
Right? That is where you definitely need a monitoring period for something like liberal access, so that you can save a parent the headache and the money of having to come back and apply to court.
Correct.
And saying, I'm not getting to see my child, only running my wrong. When I come in, they say they're going to Tobago and all that. No. That is why you need monitoring and a probationary period.
Correct. And we saw snippets of that. Shervon, we saw snippets of that same LATT, whatever it was, consultation or whatever. And they made mention of us. They made mention of the Single Fathers Association. They made mention, so definitely the discussion there would have had to been around the lines of us discussing things like parental alienation, our support for shared parenting. And as I said, she chose an opportunity to not even think about what she was going to say, but just say something so that it was recorded, or at least a seed was planted. Well, even though it was not a good seed, that shared parenting is not a good thing. She presented no research. Everything she presented was highly emotive and unfactual, no research to support it, and did not make logical sense. It didn't. You cannot suggest liberal access if structured access hasn't been shown or proven to even have worked. And the truth of the matter of it, I could use my experience. The same experience that started the whole Single Fathers Association bacchanal. I still have an access order that was issued by the court. Still in my possession. It is my son, and you know the story, fellas. It is my son who spoke to his mother and who spoke to me as well and said, I want to spend 1 week by my mother. I want to spend 1 week by my father. He did that at the age of 8. And from 8 to 16, he was never confused. He had no qualms or worries about what to write on his lunch kit or what to write in his notepad or what to write in the sky. He understood that he lives by his mother and his father, and that either address he was free to use at any point in time in any document. So to suggest that what she's trying to say, when a man and a woman separate and the boy carrying the father name, he must change it to confuse him because they're no longer living together. It's not making sense. So I can attest that at that point in time, my son was 8 years old. He did that up until 16 years old. And that is actually what brought his mother and I to a position of proper co-parenting practice. Proper co-parenting practice. It had no bad eye, no this again, and no breach of court order. And I still had the court order inside. It was that same shared parenting style that caused that to happen. Maintenance didn't become nothing again. Because the maintenance I used to pay her, we end up getting a bus that nearly was the same amount of money. And I just used to pay to drop him to school and bring him back. At a point in time when he reached Form 4, he said, hey, let me talk to Tuole again. He said, I going to travel with bus, and that money all paying for that, give me, let me save it. And we did that because it made sense, and neither of us wanted it. Simple as that. So that the reason we could have even come to that decision by the time he got to Form 4 is because that whole acrimony of fighting, my day, your day, my day, your day, my day, your day, was demolished because of what an 8-year-old child demanded. You are a senior counsel. That goes to show that she has never for a day followed up on one of her clients after she's gotten what they've asked her to, or after she's failed to do so. So she has no knowledge of what is in the best interest of a child, despite the fact that she's been paid to represent so many of them.
Mark,
no post-judgment knowledge she has to have.
Mark, are you there?
Yeah, I'm here.
I have someone just messaged and said they're trying to call to get in, but they're on hold for a while.
Oh, okay. Let me see. They're coming in there. Good afternoon. Welcome.
Pleasant good evening, gentlemen.
Yeah.
Good afternoon, brother. How are you?
Mr. Shervon, Mr. Rondell, Mr.
Yeah, man.
Yeah.
How are you doing, brother? Talk to us.
Marcus here.
Talk to us, Marcus.
Yeah.
Tell us what you think about the topic today.
Just senior counsel looking for a legal way to separate father from the mother, from the child.
Correct.
Yeah, definitely.
Yeah.
Agreed.
Looking for a legal way. She looking for a legal way.
Definitely, brother. And we know, Marcus, I know you and I spoke recently, and I know your story and situation, and this must definitely be heartbreaking for a father like yourself who is trying to be a parent to their child.
That is frightening. This is frightening. Really frightening.
Yeah. And we say in Tobago, when Marcus goes to court, Marcus shouldn't have to come up against a lawyer like that, Rondell.
At all, and another father that sent this article to me too. So from the time men saw this, who have the matter before the court, the man who sent me this to Shervon hasn't been able to see his child because a false allegation has been levied against him. He has to see the child on supervision, supervised by children authority, where the child is saying things, I want to see my daddy, I can't in the proceedings, and it's sending the man crazy. So to see that come out, he must be frightened. And then we are telling men, step up, be involved, step up, do this. We are such a hypocritical nation. You are telling men day in, day out to step up, be fathers, don't be dead, be fathers. That was the rhetoric before we started to show the side, you know, brothers. Before the last decade of our advocacy and highlighting how men have been struggling, the social perception is that man never wanted to see the children, you know. And that is why there are those that dislike us, because we've been able to show the struggles that men are going through who want to be involved.
Marcus, anything you want
to another guy just messaged Adrian, messaged like he wanted to call. So share the numbers. You could call in Adrian if you're listening.
Marcus, are you on air still?
Yeah, on air still.
Marcus, continue it. Marcus want to talk some more.
Yeah,
you want to access on there?
It just frightening. It just frightening to this point where if if judges decide to share our view and all too, that is something frightening. That is something really frightening.
Yeah, yes, we share that view, Marcus. But as the association, brother, we're going to do everything within our power with you as well, with you and every like-minded man and woman out there. Krista, I saw you just message, men are going through a lot, very true. But we need women and men to get on board so that the views of persons like the senior council are going to be the minority, and we'll trample those views out of the minds, right? Out of our judiciary and out of our homes, out of the government, because these persons should not be in places giving advice, advising any government or advising any ministry on what to do where families are concerned, where they hold these types of views. Thanks for calling, Marcus. We appreciate the call, brother. The numbers to call again, folks, it is 222-8255, 222-8255.
Hello, good evening.
525.
Somebody on the phone again.
We have another caller, Shervon.
Okay, brother, good day. How you going?
Hello, good day.
Good day. How you doing, brother?
Yeah, this is Coyote here.
Yes, Coyote.
Yes, brother.
Mr. Rondell feels no respect to you and to the other members of the panel.
Love, brother, love.
Make my story very short and sweet, right? You all hear me?
Yeah, we hearing you. Just talk. We listening.
Right. So I was in a relationship with my children, mother. Right? Well, before we had kids. Before I had kids, I got myself into some financial situations.
Okay.
And that's what I was saying. I was thinking about, family and all these things. So I got myself in some financial situation, right? And what happened? We broke up, right? When we broke up, my child mother put me in court for maintenance, right? So added to the financial situation which she put me in, right? I have to pay that, and now I have to pay money in the court, right? And right now she holds my kids at the ransom. If she look in court, I tell you honestly, I am struggling to make it. I even trying to work 2-3 jobs to make money to supply from me myself and to pay my bills, right? And right now my child mother is holding me. Every time she find out she don't see money in the court, she's not giving me my rent, right? Imagine I went to my son's schools. I pick up and went to my son's school, and my son, they are both 7 and 5, and my son texted me. I said, "Son, what happened to you?" He said, "Daddy, we tell him, mommy, we want to come at you, and she's telling me how you working." Right? When I was leaving school the evening, my son telling me, "Daddy, you're coming back?" I said, "Yeah, I'm waiting for you in Vancouver." Right? I'm waiting for. Right? And when I saw that hurt to my children, because I remember how I grew up as a youth man, because yes, I grew up with my father, but my father wasn't really there for me as a youth man. Right? He was in the house, but he wasn't there. Right? I find what I experienced when I was going through the court case is that the magistrates did not taking time to listen and analyze the situation. They just want to get the case over with. They're not taking time, because I show the magistrate my financial situation. right? And still, my child mother is working for double the salary I working for.
Wow.
You know what I'm saying? I understand that I understand that a man, Mr. Rondell, sees any other member of the panel that I have to do my very best. You know what I'm saying, to make sure that my children are provided for. Right?
Mm.
And I'm not
Coyote, let me give you some advice. I want you to know that even though you might have missed a payment of maintenance, that does not exempt her. If she has a court order to give you access on a particular time, I don't know, you didn't say that, but if she does have one and she doesn't give it to you, even though you may not have paid maintenance, she still has to follow the court order. You could still go to the station and you could still go to the court and apply for breach of access order.
Remember the protection order as well.
Correct. Do you have a court order right now?
Yeah.
Or it's just access, or it's only a maintenance order that was granted for her?
The court order is that I get my children every 2 weekends.
Well, good. So that means you have an access order. Once that access order is breached at any time, I don't care if you win $5,000, I don't care where you win. She has an obligation to still give the children to you. Right? First of all, people just think, and sometimes they feel a little bad, and sometimes you're attacked verbally. Then bringing the child and then, but you're coming for children. That have nothing to do with it. She have a court order that she has to abide by. If she does not, you go to the station, make a report, get a police receipt. The reason for doing that is because you need evidence. What you can do is when you get a 1-time, 2-time, 3-time receipts, go to the court and make applications to the family court or whichever court, the magistrate court, for 2 things. You're making your application for breach of court order under the civil court order, and then make an application also under the Domestic Violence Act as well.
Psychological
for emotional abuse. Right? The reason we're telling you to do that for emotional abuse is because the Domestic Violence Order, and this is something we asked our judge on our panel, Domestic Violence Act carries a different consequence. It takes it out of the civil realm and puts it into the criminal realm. So that if an order is then made on a protection order, that she is not to breach the family court order. Anytime she breaches the family court order, she could get locked up. The family court order, and I know these things are confusing, so I know you're on Facebook, so we'll reach out to you to explain it a little better to you. But the essence of what I'm telling you is, even though you are owing, no matter if you're owing some maintenance, don't think that you do not have the right to have access to the child still.
Coyote, are you part of our support group?
You're on my Facebook page. We should send it in the information.
So I'll put, and this is not just for Coyote, for all the men, right? No disrespect to the ladies who support us, right? But
and women too. If you're a woman and you have a non-custodial order, you're one of the few, and the man and alone, you just see a child. It doesn't have no gender with me when it comes to that, you know. Right is right.
No, and we do. I'm going to say the woman who message us on the page seeking support, we do provide guidance through there. But the Telegram support group is only for men.
Right. Coda's trying to say something. Let's hear the Coda.
One last point. I do not know where my children reside. She has not told me where my children reside. I do not know where they reside.
That's okay, Coyote. We can address that as well. There's procedures in the court to address that as well.
Okay.
So I'm going to put a link in the chat, Coyote. Yep. Please join the support group. Right? Right now, the chat that you've been messaging in, the live chat that you're messaging in, I'm going to post a link in that chat. Please click the link to join the support group, the men's support group, and we'll be able to talk in a more private setting and guide you through the processes in the system, because we know it's a lot of information for you to take in at one time. All right?
Yes. Thank you, gentlemen. All
right, but I'm going to post the link there now. So look out for it there now.
Yes. Okay, thank you, gentlemen.
They raised that point, and it goes back to what you were last talking about, Shervon. The fact that he doesn't know where the children live, Wendell. How we go get access? How you going to know where to go and pick up the child? If they don't know where the child, if you don't know where she resides, and the order doesn't say that she bring the child to the police station or something, which I can tell it doesn't say, how would he know where to go and get access?
Well, that's one of the weapons that they have been using. I've had a number of complaints about that, and I'm sure you guys have had those complaints as well, where the woman removes the children from the address where that she had given the court, and now the fathers don't know where the children are. They have an access order. She's not answering the phone but she's not answering the phone when the police calls either, or she's just ignoring the police calls, and the father has no way of finding the children because he doesn't know. In some instances, he can't even file for breach of the access order, because when you go to file for breach of the access order, he has to have an address to give to the court in order to make the application. So I've had a number of complaints within recent times about those same thing, and I advise men to go do some sort of investigation and or talk to people that they know that are close to the females, and see if they can find an address or where she's working or something like that, right? But that's one of the weapons that they are using. Apart from the false allegation weapon, they're using the false allegation weapon, they're using the sexual impropriety weapon, they're using the disappearing with the children as a weapon as well. And they're also using the protection order as a weapon against fathers.
Wendell and Shervon. And you know, sometimes people listening on a woman, some women who don't have that level of emotional intelligence. The emotions could be high. They don't know how to manage the emotions. Like I said, these men just hate women. And they're just woman bashing. They're always bashing women. Women don't understand the things that we are saying to them. This will protect them, you know. It is a dangerous thing to use those weapons Wendell talking about. That is a dangerous thing. That is a provoking thing. That is a triggering thing.
That's right.
You do not want to trigger the emotions of somebody else. You don't even, and you have to think of it like that. There, some women will not trigger the emotions of other women because they know the woman might swing and do them something.
Mash them up.
Why would you want to trigger the emotions of somebody you are certain you cannot beat physically? You do not want to provoke that in any human being. And we do not endorse anybody taking any violent action for anything somebody does. That is not endorsing it.
Correct.
But you yourself also must be responsible for how you act.
That's right.
What does it benefit you to say I spite him, or to say I got this and he do me this? So I got when I was a tea, he cheated me, so no cheering for him. Why would you want to do the children that? And why would you want to do the man that? That is triggering behavior. And that behavior, Wendell, doesn't only trigger the man. It triggers the child. So when you see the child now giving you a back answer, and the child now not listening to you, or the child reached 13 and 14 and disrespecting you, it is because the child who was excited to see his father, just like Coyote and them, you see they get vexed with their father, but eventually they going to realize who's stopping them, and they will get vexed with their mother. So even though they are children and they love their parents, the children wasn't hesitant to be vexed with their father because of what they taught them. So don't think they will not be angry at you when they realize what is the real source for them not being able to access the other parent. You are triggering bombs all around you that can explode around you. Some people trigger, you could trigger your children to take their life, boy. You could trigger your child to take their own life, boy.
The opinion box say he's trying to get in his show.
Link is he'll have to call in, because remember we do all the links are out.
Yeah, you have to call in opinion box. Gentlemen, we just have about 10 minutes to go. And I want the senior counsel to know if she's listening to this. We're going to post on our Facebook page some of the research that dispels the myths that you have about shared parenting or shared care and control. Because that is what they are, myths. And we want to be clear. You may be of the opinion, and those who are like-minded may be of the opinion that what we say is just our opinion, our rebuttal to what you're saying. But as we've said throughout the program, there is research out there that speaks to the benefits of shared parenting of the lives of children. So if you say your interest is in the care and well-being of the child, because you made that statement somewhere along the line in the article, then you should be interested in the research that says that shared parenting is in the interest of the child. And the
Shervon, the stat that was just presented, that you just presented, it also shows that it is in the best interest of her client, who is the parent as well. If the client is the woman, because it shows statistically that there is a decrease in intimate partner violence. So put an intimate partner murders and crime. So you just can't study your part of the issue. Hey, I guess she what she want, boy. Hey, happy. She get everything. He get nothing. I had the money in my pocket and I gone. And then out of that, something else arises because somebody feels a level of injustice.
That's right.
But man, as I said, there needs to be procedures that must be issued by the family court before these people are allowed to practice amongst families. This isn't the separated court. This is the family court. It means that though we identify parties have separated, we still identify them as a family unit, or at least to bring them to a position of family life. And if you cannot abide by that as a psychologist, as Wendell said, as a judge, as you said, as a lawyer, as I said, then you do not belong to be in that space. And all the family court matters, as the family court is trying, all family-related matters need to exit the magistrate court and end up in the family court, so that all family-related matters will fall right under those procedures as well.
Agreed.
Yeah, agreed 100%. And you know, you always say, Rondell, over the years, that we like to follow the wrong examples or the wrong nations. When we take an example as a country, the things start adopt. And look at what happened there in Spain.
Correct.
Right? We having a discussion here year-round in Trinidad about domestic violence, and it's only increasing, and it's only going up, and look what happening, and look, we've seen it on the news of late. Look how many domestic violence cases in the last couple of weeks has ended in death.
Correct.
Case scenario.
Correct.
Right? Physical harm and death. Right? And yet still, all we're doing is the same old cycle. But look, we have a country who say, let me try a different strategy. And domestic intimate partner violence cases drop by 50%. This same country, there's a separate report and research where they studied 165,000 teenagers who were part of households that were separated, and they found that when there was shared parenting, that the risky behavior by teenagers decreased significantly. But as you say, common sense. We always say take a village to raise a child. We always say, oh, absentee parents, we always make an excuse, right? That absent fathers is what have the country and the communities in the state that it is. And here you have a country who has said, let us use more shared parenting. And what they're seeing is better behaved children, but more productive children, less intimate partner violence. Come on. We don't look too far. Right now, we're supposed to be sitting down talking with them as a country. Hey, let me get the playbook for all you do there and see how we could tailor that to suit our environment.
We should have invited the AG from there or whoever is responsible for handing out these laws and seeing them through in the criminal courts and these places. We should have invited them here as part of your domestic violence campaign. If you were serious about eradicating domestic violence and not politicizing domestic violence.
Yep.
And fellas, that is why I always say, and I have concluded, that this is a deliberate and malicious construct on the part of certain elements within our leadership and society to keep this thing this way, because all the evidence is there. The research is there, the success of the implementation of the laws are there. They don't have to go and look for it. We put it in their faces ever so often. We make recommendations and they do nothing. So that says to me that they want the chaos to continue to reign. They want this thing to continue. They want domestic violence to be part of our society. They want criminality to be part of our society, because there are a segment of people and individuals, psychologists, lawyers, and so forth, who are benefiting directly from it.
Correct. And advising their clients to say things that are not true as well.
Yep.
To give them that segregated advantage. Because if your intent is to come to a family court and you win everything, you, with your mind as a legal mind, you know what you need to tell that person to say to get everything. That is why the thinking of a family court lawyer must be different, to come together for what is the best interest of the child. But if you are trained legal expert and your intent is for one party to win and one party to lose, you will do based on what your expertise has showed you for your party to win. And even if that means to lie, you will lie. Because lying is not a strange thing to the court. You just have to lie good and not get caught. But we will be ridiculous people to think that lying is not something that takes place in a court. That somebody knows somebody guilty of something, but now has to come up with a convincing enough lie to convince a jury that they're not guilty. And that is the type of practice that must never travel from the criminal court into the family court.
Yep.
So the court and the judiciary must mandate or put the procedures in place that that thinking from an attorney does not transfer itself from the criminal court into the family court. Because unless it involves criminal issues, and it does not in the family court, you have no reason to try to convince guilt or innocence when it comes to that aspect of things.
Yeah. Gentlemen, we just have 2
serious.
minutes left. Coyote, the link is posted. I hope you see it, Coyote. The link is posted. Please join the support group. Closing remarks, brothers.
I will go first today, brothers, and always let me go last. I would just like to thank you guys continuously for your persistence. Thank you guys for making the time and the effort for 102 FM. Thank you, Shervon. Thank you, Wendell. Thank you, the listeners that are on this platform. This is information that should be spread all over the globe. It should be on television. I continue to encourage more people to listen to these things, educate yourself on these matters. And this is the way that you will treat a lot of your issues and a lot of your frustration and fellas. If you come to these spaces and find solutions for the things that frustrate you, you will be able to better defend yourself so that you feel some semblance of justice. Because it's that feeling of injustice that pushes you to a place of mental frustration that causes you to act out of your ordinary. So whether it means it ends in the death of somebody else or it means it ends in your death, we do not want that to happen. So for those of you who continue to listen to us, anytime you come on, share this live. Anytime you come off, share this video, because the information being shared here weekly may step in the gap and save somebody's life or some people's lives. If you understand what I'm talking about.
Thank you, brother. Wendell?
I just want to encourage our listeners to share the link with men. I know that there are a lot of men going through situations, and these past weeks, I have seen, even in my own area, I have seen murders taking place because of domestic situations. I mean, I haven't spoken to you guys to give you all the real inside scoop on that mother and that child that was murdered. But at the end of the day, there are things that are happening, and as I said, that the systems and the instruments that are in place to protect women and children, there are women who are using that and weaponizing it against men, leaving men with a certain degree of hopelessness, because when instruments of law are used as weapons, like false allegations and protection orders and so on, are used as weapons against men, let me tell you something, men get triggered. And not everyone have the emotional intelligence to cope with what they are experiencing. I mean, they're already facing domestic situations, injustices in their home and in their relationship. And then when a man believes that, hey, I can't go before the court now and get justice, that's the end of the road for that man, right? He has nowhere to turn. So I encourage people, share the link so that men could join the Telegram support group, so that they could get a little help if need be.
Thank you, Wendell. Well said. The Power 102, Trinidad and Tobago, it has been a pleasure sharing this platform with you for the past hour and change. We wish you all a blessed weekend. Be safe out there, and let us continue, men and women, mothers and fathers, continue to come together. That's how we're going to make the change. Let us come together. Forget all the old talk around us. Let us come together and raise our children to make a difference in Trinidad and Tobago. Mark, over to you.
Amen.
Thank you, Rondell. Thank you, Wendell. The Fathers Association every Friday right here at Power 102 Digital for Hard Talk, where they touch on family issues. And today the topic has been debunking the myths of shared parenting. Until next Friday, they'll be back.
All right, everybody, have a safe weekend.